Well, I think when you look at what's going on nationally over the last 2 to 3 years, the healthcare case is a great example of how attorneys general across the country are engaging in a response to the overreach of the federal government. But it's not limited just to healthcare. I mean, the healthcare case has got the most notoriety, and obviously it was a case that there was very important issues that 28 states felt like need to be litigated and addressed. And it was. I mean, March of 2010, Randy, when AGs across the country initiated that lawsuit, most criticized the actions by King Cuccinelli, and at that time the Florida Attorney General, as simply being political, that it wasn't about the Constitution. 2 years later, before the U.S. Supreme Court, all of the reasons that the AGs in bringing that lawsuit were vindicated by the court and asking tough questions about the scope of the Commerce Clause and the scope of the spending power of the U.S. government. So when you look at the states at this time and you look at attorneys general from across the country, we're on the front lines and in many cases the last defender of truly federalism, checks and balances between the federal government and the state governments. And it's manifested itself through litigation, and it's manifesting itself through agency action that we're responding to. So it's a very important role that AGs are playing. Now, is that novel or new? Maybe to the degree as far as the magnitude of the issues that we're dealing with, but there's always been this tension between the role of the federal government, the role of the states, and sometimes it gets out of balance, and there's a response by the states and education or energy or banking or finance, et cetera. I think just the last 3 years it's been more acute because of cases like the healthcare law.
The healthcare law, the Supreme Court made its ruling on the Commerce Clause and upheld that it's constitutional in at least some sense. Where's that stand now? There's still issues being litigated, correct?
Well, there are still issues left to be analyzed. As an example, the issue involving the IRS. The IRS on May 18th issued a rule that said that whether a state has a healthcare exchange or not, they're going to assess the employer mandate tax. That's a very important action by the IRS under the law, because the law appears to be pretty clear that if a state doesn't have a healthcare exchange, if it doesn't adopt a state healthcare exchange, then the employer mandate tax cannot be assessed in that particular state. And as you know, there are multiple states, I don't know how many of late, but at least 15 plus, that have not adopted a healthcare exchange. So that's an issue left to be addressed. I think when you look at the ruling out of the court on the spending power, the court, in a 7-2 vote, which surprised many, said that the federal government can't engage in coercion or intimidation or threat as it relates to how they try to move the states toward a policy that they have by threatening to take away money or appropriations that states have heretofore received. So that's left to be litigated and determined to what degree is that other states going to be affected there. So there are many issues to address out of the healthcare ruling. But I will say to you, Randy, when you look at what occurred in that opinion, the Commerce Clause, for the first time since the 1930s, there was a restriction and boundary placed upon the Commerce Clause. There were many that argued. In fact, if you put constitutional scholars on a panel 2 years ago and asked them whether the law was constitutional under the Commerce Clause, many would have said absolutely, and most would have. But out of that ruling, the court, for the first time in quite some time, said that there are boundaries to the Commerce Clause, that the federal government can't compel an individual to enter into commerce in order to regulate them. That's what the states had been arguing. That was the motivation and the centerpiece of our lawsuit here in Oklahoma. We passed, as you know, a state constitutional amendment that said that no government, including the state of Oklahoma, could compel someone to buy health insurance under the Commerce Clause. We litigated that, filed a lawsuit, and that was one of the cornerstone arguments of the AGs before the U.S. Supreme Court, and the court agreed with the state's position on that. And Randy, it was quite historical for me to be there. I was there both during the argument in March, and I was there also at the time that the decision was announced. And the court dedicated 3 days of argument to this case. That hadn't been done since 1966 in the Miranda decision. So obviously the court recognized the landmark status and nature of their decision. The states received benefit out of the Commerce Clause and got, I think, a good holding out of the Commerce Clause, got a good holding out of the spending power. The difficult thing was that Chief Justice Roberts upheld the law under taxing power, and I think Justice Kennedy said it best. The court tried to uphold a statute that the Congress didn't pass. because they tried all that they could to say it wasn't a tax. But despite that, attorneys general were doing their job. Attorneys general were on the front lines defending both their respective constitutions and their state statutes and the people ultimately as it relates to liberty and freedom under our U.S. Constitution.